The Supreme Court of Canada has just upheld a ruling that the Harper government won't like. The court finds that penalties for illegal possession of a gun are too harsh. CTV's Marella Fernandez is following this story for us. Marella, let's begin with the background and how we got here.
Yeah, let's do that, because it is one of those situations that winds a little bit until we end up with a decision today by the Supreme Court. So here is what has happened. 2008, the Harper government introduced legislation that would make the mandatory sentences for illegal possession of a gun, so if you have a gun and it's not licensed and it's loaded, stricter, in the sense that if you were found that way, 3 years mandatory sentence. And for a second offense, 5-year mandatory sentences. So a couple of lawyers decided this was too cruel and too harsh, and on behalf of their clients who were getting these sentences, they challenged it in court. In 2013, the Court of Appeal in Ontario heard the case and said, "You're right, lawyers, this is too harsh." They agreed. Cruel and unusual punishment, they found, for these mandatory sentences. So Ottawa and the Ontario attorneys now took it to the federal level, and that is what we're getting today. The Supreme Court of Canada, agrees that the punishments are too harsh. 6-3 was the final decision when they heard these two cases, which means that the law has been struck down. It was already struck down, remember, in Ontario, but now nationally, this is a national decision that says you can't sentence somebody to 3 years for having an illegal and loaded handgun, or 5 years as a second offense for this kind of crime. So this was part of that larger tough on crime agenda that has been laid out over the last number of years by the Harper government. They're not going to like this, of course. One of the reasons, or one of the situations that was looked at, was a young man who had no criminal background, but did get a 3-year sentence for an initial possession of a loaded gun that was illegal or prohibited. And he would have gotten a 2.5-year sentence. So really, it was just a 6-month difference that they decided to take to the courts, now sort of winning at the high court level. It'll be interesting to see what the Harper government's response is to this. As you know, many of you know, the last number of times that the Harper government has been challenged, or legislation has been challenged at the high court level, many of those times it has not gone in favor of Ottawa. So it'll be interesting to see what the response is from Ottawa by the end of the day. Marcia, back to you.
Okay, Marella, thank you for that.
Thank you.